Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about O-1 visas. Now, you might ask, why O-1s? What's the use, the big deal? Why should we listen to you talking about an O-1? Well, let me tell you where a lot of times O-1s will have to come in. As many of you know, the H-1Bs are used up faster and faster. Basically, when the economy was not doing well, the H-1Bs lasted much longer. In fact, during the deep part of the recession, they even lasted all year. But as the economy has gotten better, the H-1Bs get used faster. And as of last year, more or less right when they were filed, within about a month, give or take after that, the regular H-1Bs were used, a couple months, the advanced degree H-1Bs. So what that means is that when they're all used up, people who have the college degrees, who have years of experience and so forth, they can't get the work permit because they can't get the H-1B. And now, even now, the doors will open again in April, and of course you'll have everything ready to go, and you'll file it out the door before, right when April 1st hits, in the hopes that it gets there. But then even then, you're looking at not being able to start until next October. Well, the way business works, people and businesses need workers now. They don't need them 6 months from now, a year from now, and then, honestly, maybe just a crapshoot if you get in the fray at all. So, what is an alternative to the H-1B? And the O-1, of course, it's not for somebody just out of college, but it is referred to as the extraordinary ability visa. Okay, and then the first thing people think is, well, I'm not of extraordinary ability. How could I make this work? Well, the first thing I do is I have to see which type of O-1 they would qualify for, because the burden of proof is a little different depending on which area of O-1 you want, and then we go from there. So essentially, if you have several years of experience and you're good at what you do, then the O-1 is a possibility. Now, it has to be, again, extraordinary ability in whatever field that you are in. Now, the way that I work this to give people a better chance is I try to narrow the field as much as possible. So what does that mean? Let's just say you're some kind of chemist, okay? I could say extraordinary ability in science, which of course that includes everything. That includes chemistry, physics, astrophysics, microbiology, all that stuff. So of course there's no way of getting it there. So then I could narrow it and say, okay, extraordinary ability in chemistry. But still then, that is that's a very broad field, and you're going to go up against some really tough competition. So then I inquire, I go, well, what is it in chemistry that you've been doing? Well, maybe they've been working, researching different areas of cancer research, and they needed a chemistry major. And, again, I could say, okay, extraordinary ability in research dealing with cancer, okay? But then I could go farther. Maybe they deal with a particular kind of cancer, and so forth. So you see, what I've done is I've narrowed it and narrowed it and narrowed it, so I've kicked out a ton of the competition because they're not in this particular narrow field. And there's no problem doing that. It just has to be properly defined. So that is one way of getting a better chance of getting the O-1. Now, what are the typical O-1 areas that are available? Okay, well, there's extraordinary ability in the science, education, business, or athletics. Okay, and that all requires a certain amount of course, evidence and so forth to show. The first is kind of humorous. The first part is you need a major international awards such as a Nobel Prize or Major League MVP. Well, to be honest, nobody's walked in my door who has a Nobel Prize. So while that is, clearly easy to get an O1 if you have that, the reality is, people don't, 99.999, 1,000 times don't have a Nobel Prize or the MVP award. So you need to look at other things, so such as see what other awards they have, see what membership in organizations which require high achievement, look at significant published materials regarding those achievements, scholarly contributions in the field, look at articles written about and published in professional journals, look at prior employment and key roles on major projects, and then look at the high, if they received a high salary relative to others in the field. So there's different ways of trying to prove this, and the reality is there's a list of 10 things, which I just named a few of them, but there's a list of 10 items that you have to look at, and 3 of them you need to get in order to have a minimum chance. Now, I can find all kinds of ways of what you have done over the last several years in order to try to fit into these categories where maybe it might not be as apparent in the beginning that you do fit in the categories. Okay. Now, what are the other types of O1s? Well, there's O1 for people in the arts. Okay. And again, the first one, sort of, humorously speaking, is a nomination or receipt of a major award, such as an Academy Award or a Grammy. And like the Nobel Prize, I've had nobody walk in my door that's won an Academy Award. But you can look at other things, such as prior starring roles in different productions, significant critical acclaim, significant recognition from governmental organizations or other recognized experts, record, and also the record of the high salary. So, the extraordinary ability in the arts, in certain respects, the burden's not as high as with the science, education, business, or athletics. But if you're looking, as I started this video off, if you're looking at an H-1B alternative, generally speaking, you're going to be in business, okay, or science, and that's where you're going to have to prove the extraordinary ability. And just so you know, there's no maximum amount of O1s. There's no time you cannot apply during the year. As a matter of fact, you can even switch, if you're maxing out an H-1B, you can switch from H-1B to O-1. So it's a decent alternative. And again, for a lot of cases that are using the O1 as an H-1B alternative, it's not my first choice. Okay, but if the choice is between trying to make a good O1 and having a go at it, and being able to stay here in the United States, change status, or get status through employment, then it certainly is a good possibility. So what are the other ones? Well, the other ones are extraordinary ability or achievement in motion pictures and television. Okay, and this is similar to the arts. You need to look at what productions they've been in, what roles they played with distinguished reputations, what commercial success they have, recognition from government organizations or other experts, and so forth. So that does sound pretty similar. And then there's specific ones referred to as O2s. Now, O2 is not a dependent. Okay, a dependent would be a son or daughter under 21 who's single, or a spouse. If you get the O1, then your dependent will get an O3, but for the O2, that is someone accompanying you, the O1 person, into the United States. So, for example, an O2 accompanying an O1 artist or athlete of extraordinary ability, you have to show the essentiality of this person, the skills and experience, and so forth. You don't have to obviously show the O2 as an O1 extraordinary alien, but you do have to show that they are required to be with them. Okay, so there's ways of bringing in several O2s for one O1 depending. You can also have an O2 accompanying an O1 of extraordinary achievement. So look and see what significant production work has taken place outside the U.S. and look at the participation of the O2 and so forth. Okay, so in that respect, that's a summary of the O1 and what is generally required in order to get it. Now, you can also apply for premium processing with the O1. So let's say that you get a job offer, there's no H-1Bs left, and let's say you have a running chance at getting the O1, you can do extraordinary ability, or sorry, you can do premium processing. You, of course, just pay the premium processing fee. It moves you up to the top, and then theoretically, if no RFE is issued, which is a big if, but if no RFE is issued, which is basically a document from immigration sending a request for more evidence, more proof that you're of extraordinary ability, you could theoretically get the O1 within 2 weeks or 15 business days. So that's a good fallback position. So the O1 is usually good. You can ask for 3 years. You can also renew it if you need. There's no maximum limit on an O1. But to be honest, if you're going through a knowledgeable immigration attorney, you'll probably get the O1, and then maybe towards the end of it, you'll switch to an H-1B at the proper time. Maybe you'll apply for a perm, maybe the extraordinary ability alien for the green card. So just so you know, there is the EB1, which is for lawful permanent residency, where you can apply as an extraordinary ability alien with very similar criteria as I've spoken about the O1, except it's much more difficult because instead of immigration just giving you the a work permit for a certain period of time, if it's approved, they're giving you lawful permanent residency. So usually I won't take an EB1 extraordinary ability without significant more experience and highlights in their career than an O1. So do keep that in mind, though, that it is across the world current. This visa is current, the EB1 for the extraordinary ability. You don't need a petitioner, for the green card one, but of course for an O1, you do have to have either an employer petitioner or an agent. Okay, it's just a little different than the H-1Bs because there's no such term as an agent to petition you for an H-1B. So it does allow you to do that, especially if you're, going to be performing or acting, and you'll get the whole calendar of where you're going to be and who you're going to be performing for and so forth. So those are the background information for an O1 and when it is that you're able to use it. Now keep in mind that, as I told you before, the RFE, which is a request for evidence, that's issued in a large majority of O1 cases, which is okay. You just expect it when it comes, and then you answer it, give them what they need, and then you send it back. Now, with an O1, you also have to have basically an advisal from either an expert in the field or someone from the union or a group which deals with this particular area, and they essentially have to write that they either don't object to you becoming you coming in this field, or and that they recognize you as an expert. This would be known as the O1 consultation. And it is required. So sometimes it's difficult to find somebody to give that. But, basically, again, if you have an immigration attorney who knows what they're doing, there's all kinds of sources that we use in order to help find who might be appropriate to give such a consultation that we can attach to the petition itself and then go from there. Okay? Now, as far as the O1 itself, there's also no requirement of a prevailing wage. So, theoretically, they could pay you what they want as long as it complies with the labor code. But unlike the H-1B, where the government mandates exactly what is the prevailing wage and what you cannot pay under, the O-1 doesn't have such a requirement. And a lot of people can get more companies to petition them if the company doesn't feel it has to pay a certain amount of money under the, as would be required with the O-1 or with the H-1B. So given that, if you like this video, go ahead and click like, subscribe. I do put out videos once a week or so, some in Spanish, some in English. But you let me know, and I will be happy to answer your questions. And go ahead and give me an email or a call for a initial free consultation. Okay, more on the coming videos.